Good evening, it's 7:15, we're in room 37, excuse me, we're at 37 Shattuck Street. This is the meeting of the Littleton Zoning Board of Appeals, Thursday, March 24th, 2016. We'll begin with administrative matters. The minutes, there was one set of minutes distributed around. Has anybody had a chance to look at them?
I did. I had comments just on one paragraph.
Let's go over them, start.
Probably the comments I gave Shelley.
Yep, right.
Was it the one about the performance bond?
Yeah, like who, what? It needs to have some kind of header.
I just looked at the paragraph that talks about the performance bond for the and it just says Chair Gould read an email, strike the D, from General Manager Scott Edwards. A lot of this is just clarity. LWD is trying to complete the wildfire project, period, capital. They have notified the owners that they need blah, blah, blah. Chair Gould then read a response email, period, capital, the ZBA will alert council for developer that that there is an LWD list of what is undone. And then there are funds available to notify the building inspector. And then next, and that Gallagher's council be notified. This was discussed and the ZBA intends to put the lender on notice. It was also agreed that any structure LELWD deems in danger of being hit. Just no, there's a comma there, just said hit be flagged with fluorescent stake, and that's it.
Just a couple comments I have to that too, please. First of all, I don't remember, Chair Gould then read her response email. Was it just a response email to, I don't remember, to General Manager Scott Edwards that I would take it up with the ZBA?
Yes.
Because it looks as though I made a response on behalf of the ZBA and I did not. So if you just say Chair Gould then read her response to Scott Edwards that she would raise it at the ZBA meeting, okay? And then, it says the ZBA will alert council for developer there is an LELD list of what is undone and estimated costs to complete of $10,000. And then over here where it says LELD wants money set aside to make sure people don't know there are funds available. And to notify the building inspector that some occupancy should be withheld. After May 1 isn't right, but I recall we were going to give the next 2 occupancy permits, but not after it. May 1. Okay, so that's all right. Until such time that LELWD's list is satisfied. Period. The board agreed Gallagher's council should be notified this was discussed and that the ZBA intends to put the developer's lender on notice. Okay? Now, just remind me to follow up with that. So go ahead. It was moved by Alan Bell to notify the developer and their counsel at COUNSEL. Anybody have any other comments?
No, they just, I mentioned to her that it doesn't say who we're referring to.
Like
So
at the top of that.
Should be a
that discussion.
heading or
Oh,
something.
yeah, absolutely.
Which
Thank you. Yeah.
which case or whatever.
Yeah. So just put, don't give it a heading because it wasn't properly, you know what I mean? It wasn't noticed.
Be under
It was noticed that we're
correspondence.
going to do it as mail, so don't give it a heading. You say Chair Gould read an email from Littleton Electric
Regarding something.
regarding the, okay,
Yeah.
thank you. And then I had on page 1, if you'll bear with me a minute too, it said, on the 7:30 PM hearing on case 865A, which is 39 Washington Drive, which is tonight, I opened the hearing and read the legal notice. I think I announced that I would be standing down when the hearing came up, but I was just presiding in order to read Attorney Duchesne's letter of continuance, right? On the last, next to the last line, the town is now over 10%, so the town can be more selective on, strike the, on proposed 40B developments. And then on the 745 hearing, case 866A, 9 Fletcher Lane, right in the middle, it says the porch as proposed is 25 feet from the front setback. And then you put, will be built to be wheelchair accessible, I put period, it will be built to be wheelchair accessible. Anybody else? Okay, I'll take a motion to approve the minutes as amended.
So moved.
Second,
Second.
Rhonda, you?
Second, yeah.
And I need a voting 1, 2, 3, 4 alternate, Mark. All those in favor signify by saying aye.
Aye.
And all opposed? No. Nobody, okay. The next item on the agenda is a little follow-up from that. I did hear back after we issued the letter, and we were trying to be so helpful to the developer on Wildflower. I did hear back that the developer was very unhappy that LELWD did not particularly care for our decision. And I contacted him to ask, where we failed, because I thought we addressed his concerns. And he did say to me, the urgency and the safety was a lot more extreme when he got to the site. If you recall, we had asked how far are these transformers from the traveled way and how far off the right-of-way they were. And Scott told me that when he finally got there, they were so close to the right-of-way and the traveled way and so far out of compliance with what was supposed to be done that he didn't think even bollards would make them safe. And so he did require a lot more of the developer before, I think he issued the next building permit that was urgent, but he was requiring a lot more from the developer than to wait until May to take care of the problem. So I think a lot got done, and I think the right result happened. I just wanted to follow up on that. Next item on the agenda is, we have a lot of notices, we always get a lot of notices from Westford because we're the next town over, and I don't see anything here that is any more than a couple of residential applications, except two. One is 434 Littleton Road, which may or may not affect us traffic-wise. It's a public hearing notice on, or no, I'm sorry, it's a decision to allow a spa in a business zone, so that one looks all right. And then there's a big legal notice for Drew Farms, which I guess doesn't really affect Littleton very much either, except for traffic. That's up on Boston Road. And I think, yeah, a farm-to-table restaurant with function hall, greenhouse, high-tensile orchards, associated parking, drainage, lighting, landscaping. I think that was heard on Thursday. I don't know what happened, but that was interesting. Then we have bills that I've signed, they're ready for payment. This can go back to Shelley, and there is a mass housing, this is interesting. Apparently, Dave Hale and the high-rise for rent 40B buildings down at the Omni Properties project are finished, and Mass Housing has sent a draft report regarding cost examination for those apartments to Jimmy Carr as chairman of the Board of Selectmen to review and comment. And I've not had a minute or two to look at this, except that the executive summary from Mass Housing, the first thing they say is that the cost exam is consistent with applicable guidelines. And they've stated the maximum developer fee, they've stated the termination of the owner's equity, and that they've complied with the annual limited dividend. So I think that should be a favorable report, and I'm glad that they were within the guidelines and adhering to them. We can't start the next hearing till 8:30. Does anybody have any, 7:30. Does anybody have any other business to discuss? I will be standing down from 3 of the hearings tonight, so both alternates will have to step up to the plate.
Was Cheryl tonight?
No, Cheryl went to a family thing. Want to report anything on your track? Have you started? the
Yes.
season? Yeah.
First track practice on Tuesday. We have 100 and, almost 120 kids in the track team between boys and girls.
Wow.
And almost 60% of the student body is participating in the spring sport.
Oh, isn't
Whether
that
it's
exciting?
lacrosse, baseball, softball, and track. So,
I
some
can't-
athletic kids in this town.
I can't remember the date, but I think they're going to start some intensive hearings on the fields,
The turf
the
field.
turf field. Do you have a date on that, in case
No, I
anybody's
don't
interested?
have,
Melissa, do you know anything about the turf fields and the date for the hearing on that?
All I know is that it's a special town meeting.
Yeah, it's a voter petition was submitted.
But I think they were going to hear something on it at the selectmen, or they already did that? I think you're
I
right.
think they already
it's-
did that.
Yeah, so I think you're right. I think they're just
They
trying
they
to-
had a thing in the paper today.
trying to get the
Yeah.
word out that there will be there will be an article in the special town meeting on consideration of, I guess, a study for the turf fields, or some money to study the turf fields.
yeah, well, the discussion is whether to go with grass versus artificial turf. Grass isn't buying anything in terms of usage.
And then Shelley's handed out 4 applications for membership for those of us on the board who are expiring, so we should make sure you fill those out and get them back to the selectmen.
So, who's expiring?
Likewise.
You're not, you have a lot of life left. The rest of us, it's
I'm starting to feel a little
Rod
tired.
Marker.
everybody else.
So I'm
Roseanne is
charged.
new, and you got a lot of
We
life.
have the
yes.
ambulance outside for,
Getting past our expiration days.
Yeah, I just gave mine to Shirley. so.
I think there's a sign-in sheet today. We have a lot of people in the room, and there's a couple of applications that I think have abutters. So can we pass the sign-in sheet around, make sure everybody gets it?
Yeah, it's on the back table there. You got it?
One of my neighbors was unable to attend, but she has a notarized letter saying I can speak for her.
When the hearing is opened,
Okay.
they will ask for abutter comments. In fact, let me do that now while we've got a few more minutes to
Well, I'm
kill.
just saying, if I'm supposed to sign in, should I sign
Yes,
in
yes.
her as well?
No, no, just your name, you're here, just who's present. When you identify yourself, you can identify who you're speaking for. So, the way the hearings are conducted is the chair or the acting chair will read the notice, and then the applicant will speak first. We allow the applicant to finish the entire presentation without interruption. Then the board members will ask questions. When the board members are through asking questions, we will hear from, in any case, if there's a town official who wants to speak for any side of the petition, we will read any letters into the record that we've received. And then the abutters or people who have an interest will be asked. When you speak, we ask you to please raise your hand, wait to be called on, speak only through the chair, don't speak directly as if you're attacking the presenter. Identify yourself and your address, and then we'll allow you to be fully heard. The acting chair will make sure that everybody gets heard and all of your issues get heard, but at some point, if it starts to get repetitive and argumentative, the chair has the discretion to shut it down. So we try to give everybody a chance to speak. This board's very good at letting everyone be heard, but it needs to be orderly and respectful. Thank you. All right, it is 7:30. I'm going to open the hearing. 7:30 PM, I'm opening the continued hearing of case number 865A, 39 Washington Drive. The petitioner, Attorney Douglas DeShane, request for an appeal of the building inspector's determination in accordance with MGL Chapter 40A, Section 8. Announcing the hearing open, I'm also announcing, Mr. Vice Chair, that I have to stand down from this hearing, as I have had past dealings with the applicant, and so you're on.
Mr. DeShane, we have a letter from you that was received it was written March 21st, 2016. Rather than me reading the entire letter, I'm going to ask you to use it as an outline for your comments. And in addition, there are copies of the letter that we have for anyone who might be interested in it. I'll say to all the people here who are interested in this matter, there are a lot of letters from attorneys on this matter. So let's start.
All right. Well, good evening. For the record, my name is Douglas DeShane. I'm here representing Jeff Garboto tonight. He is with me this evening. Jeff is the owner of the lot at 39 Washington Drive. As was stated, we are here appealing the determination of the building commissioner that Mr. Garboto's lot is not entitled to a building permit, essentially because it merged with the lot at 43 Washington Drive, a lot that was previously owned by Douglas Shaw. I have, as was stated, presented a letter earlier this week, which I believe outlined the facts of the case as well as my position with regard to the law. And I did not, while I won't represent all of the information in that letter, I'm not going to read my letter, I would like to point out some of the facts stated in the letter, and then perhaps discuss the law of merger, which is really at the heart of this appeal. With respect to the facts, it's unquestioned that Mr. Garboto individually purchased his lot from Tammy Priest. There is a recorded deed reflecting his individual ownership of that lot. This occurred in 2012. Mr. Shaw did in fact individually purchase the lot next door from Don Rice. His deed also reflects his individual ownership of his lot. There's certainly no question that at the time these lots were purchased, they were in fact individually owned by Ms. Priest and Ms. Rice, and that in fact they were grandfathered and individually buildable lots. The lots have been and were taxed as individual lots, and in fact in 2005 the building commissioner actually had determined that Mr. Garboto's lot was in fact a grandfathered lot. So at the time of their purchase, it had been previously determined that it was a grandfathered lot. After the lots were purchased, Mr. Shaw was granted a building permit for his lot. In order to issue that permit, the building commissioner had to determine that Mr. Shaw's lot was in fact a grandfathered buildable lot, and that in fact Mr. Shaw's lot had not merged with Mr. Garboto's lot. So there was an initial determination by the building commissioner that these lots in fact had not merged, because if he had determined they had merged, he would not have been able to issue Mr. Shaw a building permit for his lot. Furthermore, after receiving his building permit, or in the course of receiving his building permit, Mr. Shaw was required to go before the planning board to address the adequacy of Washington Drive. During those hearings, he was not only required to extend Washington Drive across the frontage of his lot, but the board made note of the fact that the lot next door, owned by Mr. Garboto, was also going to be developed, and therefore they required that the road be extended past both lots. And further, the board required, seeing that these lots were individually owned, they required that Mr. Garboto sign a written agreement with Mr. Shaw agreeing to split the cost of the development of Washington Drive. So clearly, not only in the building commissioner's action in granting Mr. Shaw his building permit, but also in the planning board's action in requiring Mr. Garaboto to pay for half of that road and to extend that road beyond his lot, it was clearly determined that these lots were buildable. So Mr. Garaboto did in fact sign that agreement, did in fact commit to pay half the cost of developing the road, and the road was subsequently built. And you certainly can't blame Mr. Garaboto for that. At the time, the lot had been previously determined to be grandfathered. It had been determined at that time that Mr. Shaw's lot, in fact, did not merge with his. And based on that, he was willing to sign that agreement and spend the money to build this road. So the road was built, they split the cost of the road, Mr. Shaw completed his home, and it was subsequently sold. During that time, Mr. Garaboto sought a building permit for his lot, certainly expecting it would be forthcoming, given the fact they had just given Mr. Shaw a building permit. However, some 2 years later, the building commissioner then determined that my client was not entitled to a building permit because, in fact, his lot had merged with the Shaw lot. In direct contradiction to his earlier determination that the Shaw lot was, in fact, buildable as it was grandfathered. So not only has that determination had that contradictory determination had a dramatic impact on my client, but it certainly also raises significant issues with respect to the title of the property that Mr. Shaw built and sold. There's all sorts of legal issues regarding titles and infectious invalidity when lots are sold off individually when they had in fact merged. So this situation raises a major question with regard to the title of that house at 43 Washington Drive. So let me talk a bit about merger law because, one, it's a fascinating area of the law, it really is. And to be honest, it really is at the heart of this question. The building commissioner based his opinion on a letter from town council, which I have seen. In that letter, town council includes a number of case law sites to support their position. Based on that case law, town council had concluded that two things, basically. First, that in looking at the question of whether or not two lots merged, you can't just look at the names on the deeds. But in fact, you have to look beyond the names of the deeds to establish if in fact there is legal control between those owners with respect to each other's lots. So the fact that this lot is held by a trust and this lot is held by an individual, at first blush you might say two separate entities, how can merger occur? But the law says we can look beyond that. And if in fact it turns out that the individual who owns the first lot happens to be the sole beneficiary and trustee of the trust that owns the other lot, then the courts have told us merger occurs because there is legal control between those two owners. So town council has said we got to look beyond the fact that Mr. Shaw's deed says that he owns his lot and Mr. Garaboto's lot says that he owns his. Secondly, town council has concluded that the business relation that Mr. Shaw and Mr. Garaboto share was enough to establish that Mr. Garaboto had legal control over Mr. Shaw's lot, and therefore merger occurred. I agree with town council that the case law and the law today tells us you have to look beyond the deeds. I'm not questioning that. The town had every right to look beyond the deeds of two individuals to see was there legal control that caused merger. Well, I have to respectfully disagree with both town council and the building commissioner that the law, the case law, either the case law established, referenced by town council, for that matter, any case law, anywhere says that a business relationship is enough to cause merger of lots. So I'd like to just, there are only 3 cases. I'd like to just, and town council cited them, so I'd like to tell you what those cases say. The first case is the Serena case. Now, it's important to note that in all of these cases cited by town council and relied upon by the building commissioner, in all of these cases, there was a scenario where a number of lots were owned by a single person, and the law was going to change. So they wanted to do something to protect themselves from merger. So what they did is they end up conveying the lots out to individual owners so as to protect themselves. Good try, but the case laws say this. Under the Serena case, you had 2 lots, and what they did is they conveyed one lot to a husband and a wife. They conveyed the other lot to a trust where the husband and wife were not only the sole trustees, but they were the sole beneficiaries. And the court looked at that and says, no, wait a minute. You have legal control over both lots. You can decide to put them together. The court said merger exists. In the Di Stefano case, a little more complicated, but the same thing. The case law first holds, you look beyond the deeds. And when they looked beyond the deeds, they had taken 4 lots that were all owned by the husband. They conveyed one to him, or he kept one in his name individually. They conveyed one to him as trustee of a trust. They conveyed one to him as the director of a separate corporation, and they conveyed one to the wife. Well, guess what? The court looked through the deeds and said, merger has occurred because the husband has legal control over all the lots. Maybe he's wearing different hats when he has that control, but he has the legal right to merge the lots and to use them as he wants. I found that a little interesting because the court essentially said he had control over his wife because he had legal control over her lot as well. The third case and last case cited by town council is the Nielsen case. And that was an interesting case because in that case, they had conveyed one lot to the husband and wife, and they had conveyed the other lot to a trust where the husband was the trustee of the trust, but not necessarily the beneficiary. It's interesting that town council used that case because although it agrees with the idea that you look beyond the deeds, in that case the court said that's not enough. The fact that the husband was the trustee of the trust and that he and his wife owned the other lot, that did not give him legal control over the 2 lots at the same time. So the court found no merger there. I'd like to also mention one last case, and I brought copies of it for the board. And the reason I found this case is because I spent a lot of time trying to find a case out there that said if you had business associates or people who had a business relationship who owned lots individually, that was enough to establish legal control over each other's lots. No such case exists. Otherwise, not only would I have found it, but I think town council would have certainly put that one on the list. This is a case I did come across, though, and I thought it to be telling. Rapuchik versus the city of Pittsfield. In this case, you had a mother and son who owned one lot as joint tenants, and the abutting lot was owned by the mother under a life estate. The court concluded that even though you had mother and son, and you had mother under a life estate, that was not enough to establish that they had legal control over both lots, that either individual could essentially speak for the other for those lots. So it really is a difficult standard in looking past the deeds whereby you can establish legal control. In our case, at no time did Mr. Garaboto have legal control of Mr. Shaw's lot that would require merger. They were owned individually, and the deeds reflect that. But we know to look beyond the deeds. When you look beyond the deeds, there is nothing that shows that either Mr. Shaw or Mr. Garaboto had any legal right to control the other's lot. Again, while they might have a business relationship, that does not establish legal control over someone else's property. If either of them had died during the ownership of those lots, the lot wouldn't have gone to the other. The lot would have gone to the heirs of the deceased owner. At no time could Mr. Garaboto finance or put a mortgage on Mr. Shaw's lot without his written permission, obviously. Mr. Garaboto could not sell Mr. Shaw's lot. He couldn't apply for permits on Mr. Shaw's lot. He couldn't, he had absolutely no legal rights or control over Mr. Shaw's lot without Mr. Shaw's permission. And if he required Mr. Shaw's permission for any of those things, he clearly did not have legal control of the lots. If Mr. Garaboto is not shown to have legal control over Mr. Shaw's lot, then no merger occurred. And that's the case here. There is no case law, nor has town council or the building inspector or anyone else said that the fact that these two gentlemen have a business relationship and have done work together, that gives them legal control over property individually owned by the two of them. It's no different than the homes they live in. Just because they do business together, they do work together, Mr. Shaw has no say and no legal control over Mr. Garaboto's home, nor does Mr. Garaboto have any rights over Mr. Shaw's home. So, in summary here, I do have to respectfully disagree with the building commissioner. He no sooner determined that the Shaw lot was individual and not merged, and then 2 years later, he issued a contradictory statement that Mr. Garaboto's lot had merged with Mr. Shaw's lot. That's not possible. It's not legally possible. If they hadn't merged before, nothing occurred that required them to merge later. And moreover, there is no basis in the law whatsoever that says business partners have legal control over each other's individually owned properties. If you have trusts and you have individuals and you have trusts where the individuals are the trustees and the beneficiaries, then they have control. And then you have merger. We have none of that here. So with all due respect, Mr. Garaboto is entitled to a determination that his lot did not merge and that he's entitled to his building permit, and I'm asking this board to consider that. Be happy to answer any questions.
Board, who has questions?
I have a question, a couple of questions. One is, GS Holdings LLC was evidently listed as an owner on the deed, or as the owner on both deeds at some point, right?
No, actually what happened there is that the attorney for the sellers, who normally draft deeds for their clients that are selling property, took it upon his or herself, assumed, despite the fact that we had separate purchase and sales agreements to the individuals, they were aware of the business relationship that these gentlemen shared through GS Holdings, and concluded that that must be the way they wanted the deeds written. That was corrected before those deeds were conveyed, before the lots were bought, and before they were recorded. So legally, if anyone were to ask what those deeds represent, there is no question in my mind that the individual names that are listed on those deeds reflect who owns them. That was an error of the seller's attorney, made an assumption, and a very bad one. But that was corrected at the closing prior to conveyance.
My second question is that for 43, the price of that was $89,000, or 80-some thousand dollars? Mm-hmm. All right. But the price for 39 was only $195? Mm-hmm. Okay, that seems rather, how does that work?
Well, my understanding is that that was a direct result of the seller's request, that they were both looking to sell their lots. They were selling a lot to each of the gentlemen. However, they're related or had some relationship, and they'd agreed that that's the way they wanted the money distributed. I understand there were tax implications associated with their sale, and so they requested that that be done that way. Mr. Garaboto and Mr. Shaw, it was fine with them, made no difference to them. Their individual deeds were coming to them, and, compensation was paid to the sellers in accordance with their request, so, sure.
Some more questions.
Two questions. One, what is the general business of GS Holdings? And two, on the purchase and sale, what name or names were on the purchase and sales agreements? And more importantly, who signed the checks for both these purchases? I mean, I'm just wondering
Sure,
why the
I-
seller's lawyers would make that mistake.
Well, I mean, the seller's lawyer, as I understand it, was familiar with the fact that these gentlemen do business together as G&S Holdings. G&S Holdings is a development company. They do building, they do renovations, they do all sorts of things. So it's not, it wasn't out of the realm of reasonable that's what they were doing.
Excuse me, it probably came from an email that was sent out, which was jeff@gsholdings.com. So he probably took the information off of that and, it just got misconstrued. But before anything was closed, I corrected him and said, no, this isn't in GS Holdings' name. And, he only retyped it.
And is it, Jeff, could you just verify for me that you paid individually for your lot?
Yes, I wrote a check, personal check.
Personal
and
check.
Each purchase and sale was done in our own names.
So 2 separate sales, personal checks from each, and,
One comment you just made, if they had prepared a corrected deed, then this wouldn't even be an issue.
Definitely wouldn't be. If you just went back and retyped it instead of putting
Or
line through
whited
and
it out, or-
chicken scratching next to it, we wouldn't be sitting here.
Anyone else?
Just a clarification on Alan's, Mr. Harrington's letter dated January 22nd said, Tammy Priest sold her lot for $195,000, and Mr. Rice sold, or her, Miss Rice, Dawn Rice sold it for $89,000.
Yeah, $195.
Oh,
if I
okay.
could,
That
yeah,
just
I mean,
sounds like
that's, town council had made an error.
Yeah, that
If
is-
you look, the deeds are attached, the correct
Okay.
amounts are listed on the deeds.
Roseanne, do you have any comments?
I don't. I had reviewed this when it was supposed to be heard before. And, I guess where my understanding of legal control pretty much mirrors what you were just describing in terms of if either of the gentlemen were to have passed prior to doing anything with the land, it wasn't a business holding, and so it would not have gone to the other partner in the business. Yeah, the deeds are really messy. It's not a preferred way to do a deed.
In our packets, we had an original legal opinion from a butters representative. We've now had, excuse me, 2 opinions from town council, and we've had yours. We're not usually in the situation being like the Supreme Court where we have to,
Well,
go through all these.
they do say that a zoning board is a semi-judicial board.
Well, we're aware of that because, whatever decision we make would likely result in, well, I would imagine it would. Anyway, what struck me is that while I think the ideas of looking beyond the deeds for merging is very interesting, I'm with you. None of the cases cited had anything to do with this situation. It all had to do with prior control, prior to a transaction where several different pieces of property were owned by the same person, whereas this case, it's alleged that when they bought it, it merged. You found no case law with this situation, and the facts of the case are such that there was no merging.
Correct.
Okay, any other comments? Okay.
You mentioned that if one of the owners was to expire, that the property rights would go to their heirs. Is there any document or will or trust or anything that will actually document that, or are you just saying in terms of a probate situation, it would just go, you just...
Well, again, in terms of probate situation, one's business partner, unless it's a common holding of the business, one's business partner is not in the lineage of inheritance under Massachusetts law. I don't personally know what Mr. Garaboto's will says. I can only guess that his personal assets would be left to his heirs, and maybe he wants to speak to that. But in absence of a will, as you know, the Massachusetts intestacy laws have a hierarchy of who inherits, and it's essentially heirs, as we know. I don't think business partner is anywhere on that list.
All right, so my follow-up question is there any document that specifies that a beneficiary in the case of expiration would actually revert to GS Holdings or to the other owner?
No.
Absolutely not.
Yeah, just making sure.
If the board has no more questions, I'll open it to any interested parties in the room. If you have a comment, please state your name and address, and if you want to, you can come up and talk to us directly. Is there anyone here who, yes?
Good evening, Anthony Blanco, 38 Dahlia Drive, another butter to the property. So I would just like to point out that, yes, the lots in question before the purchase happened were deemed grandfathered in. If the purchase of the 2 lots had happened, had not been filed at the exact same time with the 2 entities of GS Holdings filing for each of the 2 lots, I could see where you would say they're not being controlled at the same time, but when both business partners are simultaneously purchasing both lots and they're adjoining, I would argue that at that point, they're under common control. Whether or not, if you want to look past the deed, that's fine. They both deeds did say, if you'd seen that, the mistakes earlier on the deed, you would like to have seen them fix that before they went through with the sale, but I mean, clearly it's visible on the deed that both members of GS Holdings are acting, in my opinion, as agents of GS Holdings at that point, and therefore, the lots are joining, is the way that I see the situation.
That may be
And
your opinion, but we're here with like 3 different sets of attorneys. And it comes down to a very complicated legal situation, which there seems to be no support, in fact, other than this crossed out.
But would you
which
not,
would they have, my view is it was crossed out because it was a mistake.
would you not listen to the town council's opinion on the matter? I mean,
I of course listened. We've had 2 letters from him, but he cited no case law. And in fact, what he said in this latest thing is that while I can look at case law, our board needs to look at matters of fact. And if there is a fact that says that they jointly controlled these properties, then it would be an issue. But there is no fact that's been presented that shows that.
Thank you.
Yes.
Shafia Finger, 45 Washington Drive. I'm interested in seeing the letter that the attorney mentioned that has to do with the sharing of the cost of the Washington Drive roadway. Is there a copy of that?
I would suspect that's a public document that's on the records with your planning board.
It's the planning board.
Okay, I wonder if that is actually totally accurate in terms of the cost of a document related to the cost of developing the roadway. I attended each of those planning board sessions that had to do with extending Washington Drive. Those lots were woods, and there was no roadway. So there would not have been access to any houses that were built on those lots prior to the development of Washington Drive to extend down to the lots that are in question. And from my understanding of any documents that were signed through the planning board, there was a document that was required to be recorded as part of the deeds that said that the roadway extension would be shared in terms of the maintenance costs afterwards. It was actually GS Holdings, not the individual builders, who applied for the roadway extension to the planning board, which I think is relevant because their application was from GS Holdings, because Doug Shaw was the first person to he received a building permit. I don't actually remember what the timing was of receiving that, but he did receive a building permit. I spoke with the building inspector at that point because, we were very involved, the abutters, in the process of extending the roadway, given the tremendous impact that it had on our homes. And what the building inspector said was that clearly one house would be able to be built in there, even if the lots were determined to be separate lots, that one house would be able to be built. And that's why he was approving the first house. So, I don't know if the building inspector can be part of the conversation in terms of this decision, but that was, as I understood it at least, what his understanding was of the process. But the roadway extension was applied for both in terms of the building and drainage and everything else by GS Holdings, which to me implies that they were developing these properties together. Additionally, I do want to point out that from what the lawyer who I and the Blancos hired, who provided that letter, there was no relationship at all between the two sellers. They were totally unrelated, but happened to sell at exactly the same time with exactly the same appearance of deeds to the two individuals. So I don't think it's just that GS Holdings was originally listed on the deed and then crossed out. The implication that a layperson would have of that is that it was a mistake because there was subsequently the recognition that there could be questions around whether or not these could be considered separate lots. And so instead, the names were changed to the individual names. So, I realize that that may not be part of case law, but I think it's just important in terms of seeing between the lines of how the process of this went. So I do think it's really important to clarify the question of whether there was a document that had to do with shared costs and look at who was developing that whole area in its entirety.
I'm going to give, could either one of you respond to that?
Sure, if I could, Mr. Chairman. A couple of things. First of all, we haven't denied the fact that these two gentlemen have a business relationship. And the fact that they allowed that business to apply for the road permits is not unusual. Most builders have, a road company or a construction company that does work for them. So we've never denied the business relationship. With regard to and again, that itself does not establish that as individuals, as owners of the lots, they had legal control over each other's lots. It just shows that they had a business arrangement. With respect to the building inspector issuing the building permit, that building permit was issued for the lot at 43 Washington Drive. It in no way required that 39 be part of it, or that 39 was required in order for that lot to be buildable. The building inspector made a determination that that lot individually was buildable. And he had to conclude, in order to do that it hadn't merged with 39. Otherwise, he would have said to Mr. Shaw, your lot is not buildable. You need to come back with a building permit that encompasses both lots together. That wasn't done. So the building inspector, he did more than just guess that maybe the lots might be individual. He made a conclusion, a determination that that the lot was individually addressed. And I'm sorry, the third point was,
Well, one of the points was the disparity in price between the two lots and why that was the case, and that if these were unrelated sellers, how that could be the case.
well, my understanding, and I don't have proof, I understand they were sisters or sisters-in-law. They knew each other.
Yeah, they had a relationship. I'm not sure exactly what the relationship was, but they knew each other well.
And again, the deeds as drafted were done by their attorneys. Mr. Garaboto and Mr. Shaw in no way dictated that those would be the prices. The sellers dictated that those would be the prices. And again, we keep going back to the fact that the deeds were erroneously, drafted, and that somehow shows that these gentlemen exerted legal control over each other's lots. My explanation stands. It was the seller's attorney who made the assumption that they wanted to sell these to GS Holdings. That wasn't the case. That wasn't what the PNSs said, and that wasn't where the checks came from.
And as soon as we saw it, we corrected the issue and said, you can't sign like that. You need to put it in, one's in my name and one's in Mr. Shaw's name. And they were never recorded under GS Holdings.
What was your understanding of the relationship of these two?
Mine is that they were totally unrelated. The inheritance to each of them came separately. From my understanding, I think that the lots were entirely separate, and their relationship was entirely separate, as I understand it.
Well, that's the
That would
basis of
argue
this.
the other point.
If that were the case, why would one of them agree to accept $195 for the lot?
I don't know.
Right. And neither do we.
Yeah.
That's not our point.
Any other comments? Yes. Yes, identify yourself.
Stacy Lingbonko, 38 Dahlia Drive. I just have a question that I'm a little confused on. I know our house was built by GS Holdings, and both Shaw and were there in the sales, and so when we purchased the house, we were told that the property behind us, which is the one we're discussing right now, was unbuildable and that it would never be built upon, and within a year it had been purchased to be built upon by the two members of GS Holdings. After the purchase of the two lots, which were purchased at the same time, all of the trees were cut down in the woods behind us, and they were all cut down at the same time and placed in the lot right behind us where they still stand, dead trees. So I don't know, I'm sure there are records on who paid for or planned the cutting of the trees, but they were done at the same time. So if it was done by GS Holdings, then that shows that they were able to do, they both talked to each other about what they were doing on each lot. And in that case, do either of them have control over their lot? They're business partners, so is it possible that Mr. Shaw could have built his house without any agreement from Mr. Urbino right now?
I'll let Mr. Duchesne speak to this, but my understanding is that while they may have controlled jointly the work that was going on, either building the road or clearing the lots, they did not jointly own the two lots. And
again, we have not denied the fact that these gentlemen, through GS Holdings, do business together. However, consider the scenario where they each individually own their lots and their business relation goes sour. And they decide to no longer work together through GS Holdings. Each of those gentlemen would own a lot that they could do anything they want with it. In fact, at any time, either one of them could have decided, I don't want to be part of the GS Holdings work, and I don't want GS Holdings involved in my lot. That's legal control. That's legal control. While they can agree to work together, I've seen partnerships go south, and if this one had gone south in the middle of any of this, They would separate, each owning their own individual lot and having no legal control over the other. That's the whole crux here. Again, we're not denying a business relationship. All I'm saying is, there is nothing in the law whatsoever that provides that a business relationship provides legal control between the parties. Unless, of course, the business bought the lots, or that they bought the lots. That isn't the case. They paid for them individually, they had individual P&Ss, they have individual deeds.
And I did have one more comment.
Sure.
I didn't get a chance to get in. I'm not sure if this comes into play at all. I know that road that we've been talking about was never actually finished to the point where it was supposed to be finished. There's supposed to be a turnaround at the bottom. In the past 3 years, I have seen cars get stuck at the bottom of that hill because it's a steep hill. And if this lot gets developed, there's no room for a turnaround. So that is another thing that I just wanted to point out. I'm not sure if it comes into play.
What's the
The
plan?
road has been done exactly to town specs. There's a $4,000 bond being held until the road is finished, which is the only reason why it hasn't been finished, is because we haven't built, been able to build that house. So that's sitting in a bond, and
So
the
that's
road has been designed exactly how town wanted it.
That's a planning board issue, and you might want to bring it up with them.
Trust me, I'd love to get the road done.
Yes.
Just as a follow-up to the previous discussion about the trees, I recognize that one part of the merger doctrine has to do with common ownership, i.e. how the titles are viewed, and I would expect that common ownership also, or individual ownership also would relate to the question of probate court and who these lots would go to if one of the parties were to die, etc. That has to do with ownership. But another part of the merger doctrine, as the attorney pointed out, has to do with common control.
Legal control.
Excuse me, legal control. I'm not an attorney, but I have learned a lot about this process through the course of the whole thing. So legal control, I would assume that if, in fact, the cutting of the trees, I would agree, happened all in one fell swoop of the two lots. If that were the case, and if that was something that was done by GS Holdings, I think that does show common legal control.
I don't think there's anything in the law that would, I'm not a liar, but I can see, for instance, that you get a better price if a crew comes in and does an entire, a larger section than a smaller section. I guess my point is that none of the cases that are presented in any one of these cases that we've seen, when they talk about control, they're talking about relationship control, not actual physical building or et cetera. Am I wrong on that? Or?
You're right on point. In fact, as you've seen in the cases, the courts have concluded that when you had a mother and a son who owned one lot, and a mother who owned the adjacent undersized lot in a separate capacity, there was no legal control. And I would guess that the actual control over someone is a lot stronger between mother and son than it would be between business partners. Courts have concluded that a husband and wife owning a lot together, and then the husband being the trustee of a trust that owns the other one. He has no legal control with respect. So the courts have a well-defined threshold for defining legal control. And even blood relations and marriages is not enough.
One further question I have is that, and you alluded to it, but what it's a concern of mine, is what would happen to the title of 43 Washington if we upheld the building inspector's decision?
Well, Massachusetts has a legal doctrine called infectious invalidity. And what it says is that if you essentially split off a piece of land from a single piece, a merged piece, and you carve that off, even if what you carve off is conforming in its own right, but what you leave is non-conforming, not only is that non-conforming lot that you keep an illegal lot, but it infects the other lot that you sell off, even if that lot is legal by itself. It's called, it's like, if you create an illegality here by carving something off, even if what you carve off is legal, it's infected. And what that is a title problem. It becomes a title problem. So there is a potential title problem to the home that was built pursuant to a building permit issued by this town, and that house was sold by Mr. Shaw to someone. I guess if I was that person, I'd be, concerned what this means.
In the case of such a title problem, and a house was built based on a building permit issued by the town, does the town have any liability if this was to go?
That's a really difficult question. There's, town and town officials have certain sovereign immunity rights, and it really comes down to the action, whether it was by mistake or malicious. That's a difficult question to answer. I would say generally there's limited liability on the part of a town, but clearly with respects to banks and mortgages and title companies, they're all going to have issues. There's going to be some liability spread around somewhere. But, again, the fact that the building permit was issued for 43 is evidence that there was a determination made that there was no merger here, which is why I'm, somewhat confused that some 2 years later, and after that house was built and sold, that there's a contradictory conclusion made. I don't know, again, I don't.
Okay, any other comments? Any other board comments? Do I have a motion to
Close the hearing.
Close the hearing.
So moved.
Okay. Because of the time issue here, we have several other lengthy hearings we have to get through tonight. I'm going to postpone the discussion until after we hear the other hearings. And so that means that we're going to hear 2 more hearings, and at which point we'll have a discussion about this matter.
Jeff, can you say something?
Oh, who wants to second the
Second
motion?
motion.
Okay.
Mr. Yates? I'll vote
Yes.
in favor. I do not mind if Mr. Duchesne finishes his, and I wait and go.
Okay,
after.
well, we have one beyond that also, so I think we'll, yeah, and Sherry, did you look at the, one of the issues was, what do we need in terms of voting?
Okay.
4 or 5.
You need
4.
supermajority,
Supermajority, so that means
4 and 5.
4 out of 5, okay.
You need to call for a vote to close the hearing.
Okay, hold on 1 second, so,
Mr. Yates?
yes,
I'm the other case tonight, I
Yeah.
don't mind waiting either.
okay, but then we have another one in addition to that, so we have a busy night tonight.
Thank you.
Okay, and so do, all in favor of closing the hearing?
Aye.
Mr. Yates, as a point of order, now that the public hearing's closed, and although you will be debating at a later time, am I correct in assuming and sort of providing notice that neither myself nor the public will have any further public input with
Yes,
respect
you are
to your
correct.
deliberations?
Yes,
Thank you.
Okay, on the,
Oak Road.
so Sherry has to recuse herself. The Oak Road is next? Yeah. Okay.
Or you can open it, I'll recuse, but.
Well, yeah, you can open it, that's fine.
Gotta get a lot of exercise,
I
getting
know.
up and down with these.
I misplaced the agenda.
Okay, the time is 8:20 PM. I'll open the 7:45 continued hearing of case number 867A, Oak Road, map U12, parcel 123 and 124. The petitioner Matthew Field of Matt Bob Inc. requests for a variance pursuant to section 17331, intensity of use schedule for reduced front, side, and rear setback for a proposed new dwelling and retaining wall. Mr. Vice Chair.
Thank you.
I have to recuse myself from this hearing because I have represented the applicant.
So this is first of all, who were the voting members on this? Who was at the last meeting?
It better be us five.
Okay, so it's Roseanne, Mark, Rod, and Jeff. Okay. So as I see some same faces that were here last time, in terms of abutters and what this issue was, this continuation, this proposed house. And the issue of concern to that caused the continuation was we asked the applicant to stake out the height and location of the walls that he proposes to build for this property on the site. Did anyone was able to see it? I went by it. No, okay.
I didn't realize, I don't think anybody said that they were
I know,
staying.
I emailed Shelley this week. That being said, I'd like to invite any of the abutters that are here to comment on the staking, if you went to see it at all, if you saw it at all.
I went, I didn't see any stakes.
Well, there was some orange.
There's an orange line defining the wall and
strings.
the elevation of the wall.
I missed that.
Yeah.
David White, 17 Oak Road. There was a string.
There's a string, I know, yeah.
Very hard to see. No one could get a real view of it. I believe we took some photos of it. I'm sorry, but it was above Cammy's head, but it was very
Okay.
high definition photo, so it really was not visible, and I don't think any of the neighbors got a real view of what it was.
Okay. So there's no comments from the neighbors about?
We have comments.
Okay, well, then let's, so we've determined that maybe the staking wasn't quite visible enough. I did go by it in my car, I had to look closely, but I knew what I was looking for, so I could see it. Okay, so can I invite any of the abutters to speak?
Did we want to start with, did you want to make any more presentations?
No, I'd be,
Oh,
well, I'd like to start with saying thank you for seeing me and hearing me again. I'd also like to apologize for bringing up a local builder and a friend of mine that I had no right to do, and I apologize for doing so.
Okay. Yes.
Elizabeth Kroll, 17 Oak Road. So are we now only allowed to comment about the twine?
No, you can.
All right, my neighbor Phyllis White, who lives at 22 Oak, was unable to attend tonight. She actually got a permission slip for me
Okay.
that's notarized to speak on her behalf.
We'll trust you.
She was not here the last time either, so some of her comments have nothing to do with the string, that's why I
Okay.
mentioned it. She lives just beyond it, which on our street would be slightly downhill.
She's
from-
at the end on the left?
Correct.
Yes, okay.
Correct.
So it's her house, and then it looks like a septic field, and then a little bit of woods, and then this side.
Yes, coming from her house up the street
Yeah.
towards the property,
Right.
exactly. It's her house with her lawn and septic area, and then there's a vacant area, a vacant lot, and then the proposed property. She has major concerns with the fact that she had to have an awful lot of piping work done to get the water to not fill her basement. A lot of work. She said that it's more than 4 feet underground, that they had to dig up and all this. She's very, very concerned that if this happens, her basement's going to flood. Her septic system is going to go into failure from extra water. Again, these are her concerns, I know.
Sure.
All right?
Yeah.
She said that if they build this wall, and she and I walked out into the woods, so we stood next to the fence, and she's a lot shorter than I am. So, we stood next to the string, and she said, "This is crazy. This is ridiculous. It's going to leave a hole over here." Now, if you go to the other side of the other new house that was built on Oak Road, they're very close together. Again, not built by you. okay? Their houses are very close together, and their septic system is here, and their septic system is here.
There's a
So
space.
you've got this big channel that looks like it should have alligators in it or something, all right? So Phyllis was concerned that if you've got a house with a septic and a channel, and a house with a septic, and then a channel, and then another new house that's now up this tall, you've got another channel. So where does the flow of the underground water go? Where does the flow go across the top? It's all gonna end up on Narcissus, in my opinion, but she's just concerned that she's gonna have a huge pool of water sitting between her and the new place because it's lower, because they had to raise her septic, you know, her yard had to go up a little bit, be compliance. And then, now that's gonna be this much higher than her yard. So that was her concern.
Do you have any further concerns?
Again, this is myself, again, 17. I think 5.5 feet's really tall. I think if I had young children, I would probably have to put up a fence to make sure the young
You do.
children didn't fall out of the fence.
We do.
Fall over. So how tall is the fence? You're gonna put a 6-foot fence on top of a 5.5-foot wall? You now have 12 feet
Or
of,
fortressing the house,
well, it now looks like,
the castle on the hill.
Okay,
May I comment?
yes?
Is the elevation of our lot higher than the elevation of her lot? No.
Of the lot that Doug Shaw built for our.
No, the lot that I'm proposing, the lot that I have now, is
Okay,
the
where the
elevation
land is
of
right
the
now?
existing land elevated higher than the neighboring lot?
Yes.
Where does the
well,
water go, where does the
yeah,
water
no.
go, where does the water go now?
Narcissus.
Not off the lot we have. Where does the water go? We can't defy gravity, it doesn't go uphill.
I don't
So
think
the water,
I don't
the
think
water now
the-
is already heading down Oak Road, naturally.
Mhm.
The water that we're going to create, we're not allowed to have leave our lot. That's why we have interceptor drains, we have dry wells, we have it graded to those dry wells. We also have all of the roof gutters going into those dry wells. We are capturing 100% of our water on our lot, dispersing it down, which already now radiates off the lot.
Okay. Again, between 8 and your property, it's gonna have.
Which one's it?
The Doug Shaw house, we all know that house. Sorry to bring up the name again.
It's the one closer to Goldsmith Street from.
Pass the sugar through the window house.
He doesn't live there, they should be sent.
So again, you've got that area there where the water's gonna come and it's gonna just come up to your wall. And in the 100 feet of your lot, if it's 3.5 feet on one side and 5.5 feet on the other, then in 100 feet, you've gained,
1.5 feet.
okay? So as the road, as it continues to slant down, 22 is lower than where you are.
It's already that. We're capturing water on our lot that is going off our lot now.
I'm not getting anywhere with that, so
Right.
I'm gonna give up. Again, that's 22's question,
Yes,
and I gave it to her.
yes.
I have a question.
You're from Narcissus,
I'm
right?
Pat Robinson. I
Yeah.
live on Maplehurst, but
Oh,
I have
Maplehurst,
property
okay.
on Narcissus
Right.
Road. By the way, we have put in Narcissus Road be done as a town road. then.
Oh, good,
Yeah, we're
good.
gonna have drainage and everything, so
You
we're
should.
not going to have the mud from Oak Road. People will be pumping their water onto Narcissus. I have a question on Phyllis White's property. Her septic system is not very high. They're making you go 5 feet. Why is her septic system, which is lower, which would have more water drainage and more problems, Why are they allowed to have the lower system than you are?
Is Phyllis on Narcissus? Is she?
No, she's on
she's the
Oak
next-
Road.
She's at 22.
Oh, why is her elevation
Yeah,
of her?
her septic system isn't elevated very much at all.
I noticed.
It can be-
And
it can
why
be-
is that? Because that lot definitely is
I'm
wetter
not-
than where
we're
he's.
not
I
Board of
guess it's
Health.
because it's much wider
I
property,
think she
more
had
than
more-
100
Has
by
not-
100.
has nothing to do with that.
Okay.
With respect to Title V with new constructions, we are required to do more work. There are regulations with existing structures where you can ask for offsets.
Okay.
There are a number of different reasons that it could be lower. It could be time they tested,
Because there was a house there before.
and I don't know when Mrs. White, is that her name?
It's
Correct.
Phyllis, she's
Phyllis.
one, it was her
Yeah.
mom's house.
I don't know when it was installed, and I can't answer any of that.
Yeah.
2000.
It was installed.
I'm here to discuss Oak Road.
And when you do the septic system there and you're building it up, you're using impervious material, right? Which means that you have less drainage going through, then it really defers the seepage into the ground.
It
correct?
goes straight down.
Goes straight down, but it's all sand, right?
Yes, ma'am. It's a Presby
Which
system.
actually, yeah, right, so actually that's good for the environment.
We will not have any water leaving our site.
With just respect to the board, I guess a bunch of the people in the neighborhood want to kind of get the long and the short of the story is why the Phyllis Whites, I'm sorry, we're diagonally across the street, it might get confusing, at 22 is allowed to have the septic that's almost flat, is that now we have to have the 3 walls, and I'm sorry, we're asking for 4 variances?
Okay,
We just kind of want to find out why they can't lower it and make it more natural.
I would like it to be lower.
Okay.
We're not allowed
Well,
to.
why? But that's what we're trying to ask, and with the available properties for sale behind it,
They are not available yet.
yeah. But
so let's be clear about this. We're here to comment on the variances. We can't comment on the septic design because we're not the Board of Health. Now, the variances are related to the front setback, which more or less conforms with what's on the street already, but the size of the walls. Once walls are over 4 feet high, they become structures.
Right.
And thereby, they have to go by setbacks, which they don't follow. So specifically, the main issue that I would ask your neighborhood to think about are these walls and the size of the walls. Now, I guess I would ask you, all the abutters that are here in the room tonight, to speak to that. How do they feel about these walls? Go ahead.
Cammie Bean, I live at 27, so we're the last house on the right, so downhill from us. And at the last meeting, there was a woman who was sitting here who's not here tonight.
Cheryl.
It wasn't Cheryl. She had a ponytail.
I think the only one's Cheryl.
Was it another Cheryl? Are there 2 Cheryls?
No, that's Cheryl Cowley.
Oh, that's who it was. Okay, so she said we'd like the abutters to be happy with this big of a structure so close to the road.
Yes.
And she also said this would be the highest wall that you, the board, have ever granted.
Not true.
Okay,
Not
that
true.
was the
There's
statement
a-
she made at the time. So
There,
this is
there's,
five and a
I'd
half.
like to make a
9 foot one on.
distinction between, occasionally, we're asked to, this is a situation where it's a brand-new house. There are cases where the Board of Health approves modifications to existing structures that require these walls, which we look at differently because there's a house there already.
Sure.
But this is a new house.
Yep.
So it has, I think we could look at it in a different way.
Okay.
If I may, there's a 9-foot wall that you approved on University Drive.
I'm not familiar with that.
Yeah, we're concerned with Oak Road, so I have a number of concerns. One is this sort of terrain and troughs and valleys that we're creating on the road, which is really unnatural, and from a landscape design standpoint, I think looks very awkward and unpleasant. I'm very concerned over a 5-foot wall. We have pictures of me standing next to it, so I'm about 5'2", and the line goes to me right here, and there's pictures at all the corners, so you can see in the uphill corner it's to about here, and in the bottom corner it's at my head level. So that's going to be the wall that Phyllis will see from her house. Certainly we would be looking up and see that wall from our house. You did say that there has to be a guardrail on it if it's over 4 feet tall. And I do wonder, at some point, someone's gonna have a baby or a dog, and you're gonna want a fence on that wall, just as Liz said, and it's gonna start to look like a medieval fortress back there. Really out of scope with the neighborhood, I think. I mean, we do have Julie's house, the Doug Shaw house with one of these structures, and it looks very odd on our street, which is, you know, lots of big lawns with lots of grass, and very natural. I do also have a concern. I mean, Mr. Field, you said that this delightful young couple ultimately wants to live down by the lake, which is great, but I have a concern that the long-term view of this neighborhood's not really in your sights right now. We've all lived here for a long time. I'm the newbie on the block. Well, Julie, you've lived there less than a year. We've been there 11 years. Everyone else has been living in the neighborhood 40 years, 30 years. We're not going away. You know, we love this neighborhood and it has a feel to it. And I think this will really change the character of just a house with eight houses, a street with 8 houses on it. So I'm not in favor of it. I think there are options. There is land there. You might have to wait for it, but those other lots are there. And there's a possibility to create something that will look great, will fit in with the character of the neighborhood, and give you a fantastic house.
Any other abutter comments?
Pat Robinson,
Yeah.
Maplehurst, land on Narcissus. If you don't, you know, I know the neighborhood is beautiful. I've been there. The land that my home is on is in the family since 1928. Jerry Redmond, who lives on Narcissus Road, he's been there. His grandfather owned that property, and Evelyn's father owned her property. So these are people on that road that have been there forever on Narcissus. Their concern, that is a suggestion for the people on Oak Road, is that Matt get land on Narcissus and put the septic system there. Narcissus Road, property owners very much against that. Matt can do a beautiful home and do a beautiful wall and a lovely home on Oak Road with the septic system on Oak Road. It won't hurt the neighborhood, it will be nice. What's the suggestion for these property owners who own a lot that is a buildable lot? If the neighbors don't want a house, are the neighbors going to buy that land and give them a fair price for it? Or is the town going to buy that because you can't build on it? It's rather not fair that if somebody owns property and they're willing to abide by the state statutes of Title V and it's more expensive to do that, to build a wall up and build the land up and have all that sand. What do they suggest we do with their land?
We're here to talk about variances,
But we don't-
which by definition, and sometimes don't even allow variances, by definition, it's breaking the rules, where we give a special dispensation to break the rules that everyone else abides by. So that's what we're here for. And so to say that it's unfair, I think you can look at it in another way. It's unfair with someone who lives next door who has abided by the rules, and then someone is allowed to break the rules next door. Is that fair? I'm not saying that that's the specific case, but that's the process we're going through now.
How about the landowner that's paid property taxes on a lot that's valued at $100,000? That's his retirement. That meets state regulations.
That you still need variances.
I understand that. That's why I'm here.
Yeah.
I mean,
If you can do it without a variance, then you don't have
I
to.
also have, in the period of our last meeting till now, which we discussed in the last meeting, I have requested to the selectmen that we purchased a lot behind us on Narcissus, which is the larger one, and the other two are on the April town meeting, which brings up a bigger problem for you people on Narcissus and down in that area. If that becomes up to somebody else and they purchase it, you'll be getting a house on Narcissus.
Okay with me.
So I don't want to build. I'm here to get the requirement for that. My ultimate goal is to purchase the 3 lots behind it from the town and build a house that will allow it to be built in the taste that I like to do it. I mean, if you go up and look at the houses that we've done, they all blend beautifully with the landscaping. The walls fit.
And you've been able
Perfectly.
to avoid the walls because of the way, anyway?
No, we haven't. We've actually built walls on every single one of our properties. If you go to the one we just closed on Manchester, required a wall. The units on Lincoln and Washington require a wall. The units on Dahlia require a wall. They all do. I mean, today,
The
if you
wall-
go,
Well,
they haven't
Matt-
required a variance for
Right.
the elevations.
Right.
And granted, that's the case.
okay, so,
I would just like to clarify one thing, I don't know if Mrs. Robinson understands or not, but Mr. Field does not own this property, am I still correct on that?
Correct.
He has a purchase and sale agreement, so he is not, we are not restricting someone that owns the property.
But you are
He
restricting
is
the
trying
gentleman
to
who
buy
wants
the
to sell.
property and an additional property and combine them to make it a buildable lot. So I just wanted to.
It's a
make sure that
buildable,
that's-
it's a buildable lot now with the request for the variance. As it sits right now. And that's what I'm here.
What I'm, right, but
With
I'm
the
just
three
trying to be
things, the
clear,
top-
it's not a buildable lot.
that's fine.
The hardship to
Unless it's
topo.
a request for variance, correct.
Yes.
I'm not an abutter to this, am I able to speak?
Yes,
as a
absolutely.
representative? You know, given the, Shafi Finger, 45 Washington, given the, my understanding of this issue, which has some similarities to upcoming issues in our neighborhood with the small lots that people, that builders are looking to develop, I share the concern about the height of the wall and the safety issues, both the aesthetic issues and safety issues that would be inherent in a wall that is so high, being cast, you know, in terms of the precedents that are being set.
Thank you. Are there any more comments? What I'm going to do now is open the discussion to the board to basically, if you have any questions and what your comments are and how you're thinking about this particular issue, present.
So are we going to do a poll of?
We're going to talk about what the issues are.
I guess I'm just wondering what, if any, alternatives there are.
The only alternative we have is to get these 3 lots and slide it back, which I want to do. And I can't do that without getting approved for this. As we said before, we're in a tough position, but I'd be glad to put it in writing that we're going to be combining it. These 2 lots, as I've said before, once I own this, I'm the only person that can buy these 2. And we put a request in for this lot to the selectmen to have us on in the April meeting.
So timing is everything.
Well, it is, and and I understand, I've lived in Littleton my entire life. I take pride in what I do, I take pride in the product that I put out there. My clients they love what we do. I have one right here that will, I'm surely speak highly of what we do. And you're near an abutter to what we've done, and you're an abutter to a septic system that we just installed.
Yeah, which I will say, and this probably doesn't impact this particular decision, but there are such things as neighbors granting easements for fill.
Right.
You know, so that it doesn't, you know, you don't get this waffle iron look. And, you know, of course, that entails the abutters being willing to do that. You know, I guess in a best-case scenario, the timing would work out that you would be able to push the house back and eliminate the need for quite so high a wall. I did drive by, it was kind of dark by the time I was able to get down there, so it was difficult to see the thin line, but it was higher than what I had envisioned. And, you know, living in a neighborhood where there are some walls, I look across the street to a house that has a wall. It's very nicely landscaped, but it is, you know, higher than some of the other houses on the street.
They're a fact
You know,
of Title
It's
V.
not the neighborhood, and hardly any of the neighborhoods are the neighborhoods that they were 30, 40 years ago. So, you know, again, you kind of have to look at all aspects. I can completely understand the concern of the height and looking at or imagining what a retaining wall of that size would look like, and trying to imagine how would you landscape it to sort of mitigate this wall, never mind the fence that has to go on top. So I'm torn right now, if that's
Okay.
what you're looking for.
Mark?
Yeah.
By the way, where did you get this, this waffle iron look? Is that something that's out and about, that term? I love that term.
That's a great
That's what
term.
That's a great
what I
term.
think of when I
And
see
and
the
if,
waffle
and if it
iron.
isn't in common usage now, it should be.
Added to the lexicon.
Yeah, anyway.
Just a couple of questions and comments. And you probably answered this last month, but the wall you're putting up, what's it going to be made of, and what will it look like from the outside looking in? It's not going to be look like a basement.
No, we use the segmented block walls, either with the decorative, what are these, what size is this one? Blocks?
16 inches by 4
Yeah,
feet.
they're very similar to the walls we're using on all of our property, actually. They're aesthetically pleasing.
Rusticated, they.
Yeah, they have a
Yeah,
rock.
okay. So it doesn't look like a
No,
facade.
it's not
a
That's kind of
metal bar
concrete wall.
sticking out of it.
No.
Okay. So it does have some aesthetic value.
Yeah.
Yeah, if not a New England stone wall, next best thing. I did take a look down that street, I saw the road. And you're right, looking at the lot, the one on the left is about 3 feet. The one on the right, yeah, a little on the high side. One thing is, almost anything you do to that lot's gonna be an improvement. It looks like someone's been using it as a fill dump.
They have been,
are.
they are using it as
They
a
are
build-up.
dumping it there.
He is.
Well, I don't believe you own it, so I'm not sure. you
Nah,
gave permission. But anyway, the problem, suffice to say, right now, anything would be an improvement.
It was beautiful a year ago.
Okay. So it looks like this is a contingency plan that you would hope actually doesn't come to fruition because you're planning to buy the lots around it, in which
Correct.
case you'll expand it.
Correct.
If you had to give me odds on
100%.
that you, unlikely to build this, that you will build something else.
Oh, I will build.
No, that you will build something, that this isn't the end plan, you're actually.
No, this is absolutely
Yeah.
100% not what we're gonna do.
Okay, so granting this just gives you the leverage, if you want to use that word, that allows you to buy the surrounding
Correct.
properties. What are the chances of something happening that you can't buy the surrounding property?
The only way that would happen is if, and it would absolutely stink for everybody around there if that happened. If somebody else came and purchased this one lot that goes to auction, that we put the request in. As far as I know, with talking to Mr. Venuti, we are the only ones that have put a request in for this one. And this one over in the far corner, which is next to Phyllis, right?
Phyllis.
Phyllis.
Evelyn is on her sister?
Evelyn, I'm not
Yeah.
a sister.
Or Phyllis on Oak?
This,
They've
this,
got-
Okay, that's beside the point. I'm just
No,
trying to get
my-
the question answered.
we actually had a bid in for this one, and it came too early because we didn't have the approval for this, and I'm not putting out $8,000 for that. It's.
Now, there are a couple of properties that you say have to go to town meeting.
Yeah, these two middle ones are on the warrant.
So that's
We're going on to
motivation for
what's-
your neighbors to go to town meeting.
Yeah.
Positive.
They're on the town warrant for going up as part of the abutters list. As I went through before, there were two types, auction and abutters list, direct abutters.
Okay, thank you.
Ron? Okay, on to the right, is there a house in that lot, or is it still empty?
No, it's an empty lot that I tried to purchase, and he's a gentleman down in, I believe, Newton, Mr. Witten, and he did not want to sell.
Okay, and he's not here to give his opinion?
No, he has actually said that he's not opposed to this.
Well, yeah, unless we see.
And I believe Shelley has a letter to that, or he spoke to Mr. Witten.
Yeah, from the board, he didn't come to the Board of Health meeting, he didn't have any issues with the system at the Board of Health meeting.
Okay, and did you say that the purchase of those two lots are in an April special town meeting warrant?
Yes, sir.
What date?
Well, they're on the, I don't know when the April meeting is, or the spring meeting, they're on this next town meeting.
Okay. And the fact that you have a purchase and sale in place, I would think should go a long way to saying that you're effectively in a butter to this.
No, what you only have is equitable title on the property, and you're an attorney, better than me.
So you need to actually purchase the property.
Thank you.
And if you didn't purchase property, you wouldn't be allowed to purchase those.
Correct.
That doesn't make sense to me, the fact that you have a purchase and sale. Because I have a couple real concerns. Number one, if we approve this, there's no guarantee whatsoever
I'll put
that
in
you
writing.
won't build this plus build another house over here.
I will put it in writing.
You can put it in writing, but unless it's legally binding.
I live in town. I've been here my
I
entire
understand
life.
that, but where I'm sitting, there's nothing, it's basically your word. Secondly, there's a house near me that has a cement wall, granted, not the interlocking bricks, that does not look very attractive, but they at least have the advantage, it's across the front of the yard, and they own the land in front of it, and they can put in some shrubs and try to screen it. In this case, this wall is so close to the property line, there's no way you could provide any kind of screening. It has to go on on this Witten's property. And, that concerns me. It's just, and we've mentioned this, I think, before, it's just, you're just trying to squeeze something into this lot. I don't like the wall, I don't like that height wall, and I don't like it right up against the property line. It was 3 feet back, so you can put some screening in there, I wouldn't have quite as much concern.
I will be able to do that, and I will put in writing that we will do a redesign as soon as we get these lots, which pulls the wall away, lowers the elevation of the wall.
I understand that, and that's what I want to see, but I have an issue with approving something that you could build.
Isn't there a way that we can write it up legally?
In the variance?
Can't you put it in the variance?
You're asking us to do a prospective variance? No, there's,
Okay.
no.
This is my first time doing this type of thing, so.
Well, anyway, are you done, Rod?
I think at this point.
Okay. Al? I want to go back to the waffle iron look. We're getting these. I don't think they're right for the abutting properties. While I think there is an interest in developing these properties that are, underutilized, they should be developed, and I think our board is, we've given you a lot of consideration. I think we give consideration where it's due. In this case, I think the wall is too high. It can't be screened. I think it's a big imposition on the street, on the neighbors on the street, and they've come here to say that. So, anyone else?
Question I have is, I still, and I'm sure you spoke to it before, in a previous meeting, but I still don't understand why you have to have something so high. Is there a bedrock issue? Or
No, we have good soils. We have, what you have here is you have high groundwater, which, under the regulations and Title V state that you have to have a septic system so far above seasonal high groundwater.
So the
But you're going to be
groundwater
able to lower that though if you go back.
Correct. And we'll be able to move the walls off the lot line.
But you still have walls.
Yes, you will, you won't back on this area because you can slope the proper way.
And once again, if it's under 4 feet, we don't.
You won't have, I wouldn't be here.
That's right. Well, you would be here for the
offset to that, yeah.
front setback, which theoretically would. So, I guess we're at the point now where, are we ready to close? Do I have a motion to close?
If I'm gonna get turned down, I would like to continue the meeting and have legal counsel come.
Okay. That's fine.
One comment I'd like to make is, granted that Mr. Field doesn't own the property right now. He would like to buy it in order to give him the confidence to go forward with this project. He needs this variance, which in reality he doesn't want to do. The full intent is not to build this, to build something larger. So it's a chicken and the egg situation. Let's look at another situation. The existing owner who owns it comes to us with this same plan. would we turn him down? And he claimed, look, due to soil topography and whatnot, I've got to do this. Would we turn him down?
Well, he would be, I think so, based on, but he would be in a better position to buy the adjoining properties. That's the, you know, what Mr. Phil is asking us to do is basically be his business partner in this transaction. And I understand your situation, but it's not up to us to pave the way for you to do this pretty difficult transaction. There's a lot of people that would like our help in something like that. So, if Mr. Field wants to continue this, is there any objection?
Another question, though.
Yeah.
You said if it was a 4-foot-high wall, we would have no issue, there'd be no issue. We wouldn't
4
be-
feet, a 4-foot wall becomes a structure.
So
Yeah, we're looking for, and it's a 4-foot wall or it's a 5-foot wall?
It's a 5-foot wall in the back corner and on the side here.
So if it was 3.5 feet, there wouldn't be an issue?
No.
Because it doesn't have to be set back.
Yeah, because I don't think anybody's objecting to the setbacks on the dwelling itself.
No, I think we,
The dwelling meets it on the sides, it's the front.
it's the front, and the other new house that was built in the same.
Yeah, and I have no issue with
Yeah.
that.
So it's basically the height of the wall.
So would I be turned down now? Would you turn me down?
I'm not going to support a 5.5-foot wall.
Mr. Stewart?
No.
Mr. Sasia?
I tend to agree with you. Allow.
Allow? Mrs. Bales?
Honestly, after having driven by and seen the thin line, it's just so high on that side. And, you know, I do understand the situation that you're in terms of picking up the other 2 lots. I mean, your comment kind of hit it, being business partners. You know, it's hard to, I don't think that's what we're supposed to be here for, is, you know.
I think we're reacting to the fact that most of, everyone on that street has come out tonight and voiced strong concerns about the proposal.
By helping in a butter, you're taking away the landowner's rights.
What
You
are
truly are,
his
because of-
prospective rights for something that didn't exist until you came along?
He's paid.
I don't want to get, listen,
I think.
let's either continue it or we'll close the hearing.
I think we'll have
and
to
vote on
continue it.
Okay. Is there any objection to continuing?
No. Do we need something to allow
We have
them to give us
we
more?
have yeah, you, Shelley, he needs to grant us an extension. And then if we could have a time to continue it. Is it after town meeting, the next meeting?
Yeah, that's my question.
Yeah.
Would it be continued?
Do you want to
after-
continue it to after the town meeting?
Do we know when the town meeting?
Town meeting's
I-
ready, something?
that-
May 2nd.
Or do
I
you
think
wanna-
the only one that would really matter would be the selectmen's meeting of putting it on in April for that one lot. Because the town meeting, I believe they're gonna approve to put
Sure.
those 2 on.
Yeah. Okay. And when do the selectmen meet? Do you know when they're going to?
I believe it's the 11th. I know they're meeting at the 11th, but I don't think,
I think he said, he emailed me back and I believe he said the 16th.
And what would our next week's meeting be? Next month's?
April
21st.
21st.
Okay.
what would that one be, Shelley?
April 21st.
So if you have a board of select, it's up to you. Do you want a 1 month or 2 month?
I'll take a 1 month.
Okay.
Okay. Anything else, Shelley, on the agenda?
No, not at this time.
Okay. I move we can, well, assuming
Yeah,
we
I'll
get.
take a motion.
That's, assuming we get that extension granted, I move we continue the public hearing to April 21st at 7:30.
I second the motion.
Thank you.
Thanks. And so for the abutters that are here, there won't be a further notice of the meeting, so it would be 7:30, April 21st.
Vote to continue.
We didn't really vote.
Call a vote.
Motion on side, you vote all in favor?
All in favor?
Aye.
Okay, Cheryl.
You have, what, 90 or 100 days?
She got to recuse herself.
One of the most interesting hearings I've had in my entire career here.
I know, I feel like you're on the Supreme Court.
We're actually doing something
And
productive.
I'm tired to think about any type of agreement we could work out with him about if he can do this and if he can do that.
So that's all I
Oh, I think we can't talk about
You are absolutely doing an amazing job.
Oh, shut up.
No, you're doing an amazing job.
So let's just get through the rest of this.
Did you vote on your continuance?
I think the most amazing thing was
Yes.
the waffle iron. Because that totally describes what's going on.
You do a topographical map of Littleton, it'll be this
Or
waffle
the
iron.
waffle iron.
We'll pour in batter and have the Guinness Book of Records for the largest Belgian waffle. In the winter, it'll be like.
Okay, it's a little
Like
after 9. I'm going to open the 8 o'clock hearing of case number 868, 3 Evergreen Road. The petitioner Marilyn Berg's request for a special permit pursuant to section 173-58 for an accessory dwelling. Mr. Chair, I need to stand down again on this one because Marilyn and I have had a past relationship.
Okay, so we'll all be voting on this, all of us that
Might want to wait
remain.
until Rod comes back in.
Okay. We'll wait for our member. I hope yours is simpler than,
Oh, I hope so, too.
okay.
Which one is this again?
3 Evergreen?
Oh, okay.
So would you describe what your,
Sure.
what you want to do?
My name is Marilyn Berg. I live at 3 Evergreen now. I built the house about 6 years ago. And my mother then moved into town about a year later. And she's 85 now. And every time there's an emergency, I hit a high rate of speed down Goldsmith trying to get to her house. So what I'd like to do is build an accessory dwelling, 600 square feet.
You
One-
submitted plans.
I submitted
Yeah.
plans, I think you
We
guys
have
have
copies of
everything.
them, yeah.
And it went before the Board of Health. The Board of Health approved a 600 square foot. They asked me to pump the septic once a year, which is fine by me, and I think it's restricted to blood relatives,
Yes.
something like that.
Functional dependency.
Yeah, I mean, she needs medical help and doctor's appointments. I need to be able to care for her daily. So, I did submit all the plans. I think is that the only, and a 2-bedroom restriction on the deed, which is fine by me. That's what I have now. I live in the house by myself, and I'm hoping to answer any questions
So
you may have.
what happens in these situations is that you come before us for a special permit to do an accessory dwelling. The special permit runs for 3 years, at which point you, and hopefully you'll have many 3-year extensions, I hope.
I hope to, but
And so you would, every 3 years, just notify the, building official that you'd like to renew it. So, board, anyone have any questions?
Am I right to assume there's no nonconformities on the lot? The lot size, setbacks, and everything else is fine?
We're
Yeah,
not,
I believe
so
so.
I guess we can think of this in several ways, because that is an addition to the house, and actually, it's a good point, I didn't think of it in terms of approving an addition, but I don't think she's increasing any nonconformities.
No, it doesn't look like that. Well, let's see, the
The lot is non-conforming, but the actual
Yeah.
structure is
Right.
not,
We're
she's
not
not
in-
increasing any
We're
of the
not
setbacks.
increasing the
So,
nonconformity,
yeah.
okay. Because otherwise it'd need to
Right.
be written in, I think.
Right, so it's a straightforward thing.
yeah.
Any other questions?
Well, according to Google Maps, you have a Demoulas across the street.
What? I promise you there's no Demoulas
No,
across the
this is
street.
Google Map, and I don't see Demoulas.
Oh, okay, no, it says right here. Yeah, so, just because it's on the internet doesn't mean it's true. So, okay.
And it looks like a very wooded lot, too.
It is, yeah.
Yeah, so that'd be kind of obscure to a certain extent from your neighbor and so on. as well,
Yeah,
so.
I think there's another, I measured it out, and I think there's another 30 feet on the other side
Yeah,
with the
Yeah.
pine trees.
Yeah, she has 29, more than enough setback.
Are there any abutters here to speak to this? Or anyone else who wishes to speak to this matter?
The only other comment I have whenever we do any of these is what happens after, like I said, hopefully it won't
Yeah.
be a long time, but it's no longer needed. What would you do with something like that?
Well, I do have a little dream there. Right now, my workout room is in a cold basement, and I would probably move it over there. And I also have my own business. And right now, not Demoulas, sorry, Matt, but I'd probably give up my office downtown.
No, you won't.
And move it there.
Okay.
Yeah.
Any other questions? Can I have a motion to
Move to close the hearing.
close the hearing? Okay.
Second?
Could I hear a motion to?
Well, first you have to vote on closing the hearing.
Okay.
Any abutters?
One of the things you keep
It's a
forgetting.
group effort here. to
Were there
run
any
this.
abutters that?
There, we asked.
Oh,
we
okay.
asked.
Before I interrupted the
Uh,
question.
Is all in favor of closing the hearing?
Aye.
No opposed. Next question. Is there any discussion? Or have we covered the issues?
Pretty straightforward to me.
Could I hear a motion on the matter? Motion to grant the special permit.
One of the permanent members should make the motion.
Oh, come
So
on.
that us alternates can learn.
You didn't have the-
Go ahead, Alan.
Permanent members, trying to get us out of it.
Someone give it a shot. Motion to grant the petitioner her request for a special permit pursuant to section 173-58 for an accessory dwelling at 3 Evergreen Road.
Okay.
Any second?
Also move. Yeah, I don't
Okay,
think-
Rod moves,
But I'll
okay.
move you what you said, that's fine.
And do I hear a second?
Second.
Can I have all in favor of the motion?
No, but you didn't vote.
Opposed? No? Motion passes?
Oh, thank you.
So you can deal with the
Appreciate it.
building department and good luck to your mom.
Oh, thank you so much. I appreciate it. Thanks, Matt.
It's 2-week appeal, does that apply?
Did you speak for
Probably not.
No, no,
Right.
special permit.
Oh, okay.
Is that something?
Oh, thank God. Am I done?
I don't know, somebody might have an objection.
Okay.
Presentation disorder, we could see them.
Okay.
Great.
Yeah, call me tomorrow. Okay. And I'll tell you what the next steps are.
Okay, the time is 9:10. We apologize to everyone for the lengthy meetings tonight, sorry. We're calling the 8:15 PM hearing on case number 869A, 80 King Street, petitioner Carl Strathmeyer's request for a special permit pursuant to section 17368, conversion of dwellings, and a variance pursuant to section 17336 on premises signs in residential districts. Madam Administrator, for the record, I had recused myself in the past on this property when I represented the sellers of the property to Mr. Strathmeyer. I have no legal business relationship or financial interest in the property or Mr. Strathmeyer anymore now that he's the owner, so I don't feel I need to recuse tonight.
And you need to appoint a voting alternate.
Okay, yes, I do. Were either of you on the hearing before, when you came before the board?
Yeah, I was, yeah.
Then why don't I leave you on for this one? Because you'll be familiar with it. Okay. Go ahead, Mr. Strathmeyer.
I can begin without the presentation. I just brought some of the images on a computer memory chip so that the folks in the audience could see the images as well. We're here tonight, my name's Carl Strathmeyer, as Sherry said. My wife Andrea and I own the Minor Chord Music Store, and we had purchased the former Weber property. You folks granted a special permit for mixed-use residential retail last September. We acquired the property in December, began renovations. The renovations on the retail portion of the premises are now pretty much complete. We're in the final inspections, and we're ready to move in. So I'm here tonight on two matters. One is that it's come to our attention that although I showed you documentation from 1962 that the building was then remodeled for two-family use, it's come to our attention that that two-family use was never properly permitted because that was before the zoning bylaws required any sort of a permit. So my first petition this evening is to do whatever we have to do, special permit variance or whatever you find appropriate, to authorize the residential portion of the use to be two-family, or really to acknowledge that it has been two-family for 50 years. That published record, that published magazine article was part of the record that we included back in September, and I have copies of the pages here on the presentation if you want to see them. That magazine article says in bold print, it's also included in your materials, I think, says in bold print, renovated for two-family use. It was a promotional article done by the gypsum board people, I think, that were so pleased with the results. And also there are floor plans in there that show very clearly that there were 2 sets of kitchens, 2 sets of bathrooms, 2 sets of bedrooms, 2 sets of living rooms, 2 sets of dining rooms in 1962. So really, I think that first petition, in my mind, is simply we do whatever I's we have to dot, T's we have to cross to continue, or to allow us, the new owners, to have the benefit of that same historical use. Okay? You want to stop there for questions, or go on?
Just stop for a minute,
Okay.
Carl, if you don't mind, Mr. Strathmeyer. I just need a point of order here and procedure. You asked for, in your application for public hearing, you asked for a special permit, and the first request for the two-family conversion is under our zoning bylaw 173-68, which is, you're correct, allows as a matter of right a conversion of any structure built before 1951 into a two-family structure. This has nothing to do with the building code and the building code requirements, but does have to do with the zoning code.
Yes.
And I think you're clearly laying out that you're before 1951, but I'm worried about whether we have a good publication. So,
Because you're requesting it for an accessory dwelling, which you're not really,
well, we've advertised for a special permit. Did we also advertise for a variance? And
Because
the variance portion of this application says 173-36, which is the sign bylaw. So you haven't really cited the correct section for conversion buildings. So I'm going to ask you to make it, oh, yes, you have 173-68. It's there. Okay. I wanted to ask you to amend it. So we're easily just on the 173-68 board, and we don't even have to go into a historic use of the property as two-family. So I'll stop there and then let you go to the second half of your request.
Can I just ask a question out of
Yes.
curiosity? Did the Webbers use this as a two-family, or did they convert it to one family?
Oh, no, it was a two-family. It was the Webbers who did the renovation that was then documented in that
Okay,
magazine.
so it's, because I didn't realize that. So if it's been continuously a two-family,
He probably doesn't
then
even
it just
make this.
continues to be a two-family. Why do we need to
Yeah,
do anything?
Because he needs it legitimated for your bank and other purposes.
There was no documented public record of it being a two-family. There's this, published magazine article and common knowledge, but there's no permit or anything
But
else.
basically,
I
we're
think
just
Mr.
continuing, so it shouldn't be an issue.
Yeah, I think Mr. Stewart's point is, if it was an unbroken use as a non-conforming two-family predating zoning, there's no
Yes.
reason you should have to be here, but you're here anyway, and
I'm
I'm
here,
here,
and,
and we'll make it formal.
I
Okay,
mean, that answer is certainly sufficient. I mean,
okay, go ahead now on the
So,
second half.
Second petition is, okay, so let's see. Presentation's up there now. So the status, I talked about the status, and we've moved on to the two-family occupancy. We've talked about that. Okay, you can flip through all the copies of the magazine article, which we don't need, which brings us to the petition for retail signage. Okay, so as I said, you issued a special permit for the mixed-use residential retail back in September. We're ready to move in, and we're now requesting the board to approve signage, which comes before you because, as I've explained in the more extensive written material before you, this is a residential zone. So when I applied to the building department for permit for the sign, of course, they denied it, saying, hey, it's a residential zone, you want more than 3 square feet, you can't do that by right. So you have to go before the board, which is why I'm here, and have them issue, again, I'm not sure if it's a special permit or a variance. I suspect it would be a special permit in this case, authorizing such a sign, and then the building department can issue the permit for the sign's construction. So I have images of the signs. You've already-
And just,
Yeah?
excuse me, one more minute, point of order on this one. That is a request for a variance. You are varying the zoning bylaw that restricts signs in residential zones.
Okay.
And therefore, you have to state in your narrative to us what is your specific hardship and what conditions owing specifically to the soil shape or topography make your property unique in that you're entitled to this.
Okay. So in terms of hardship, as I said, the board has authorized mixed residential retail use. Appropriate signage is generally an assumed part of a retail operation. It's kind of hard to have a retail operation without some sort of signage that passers-by can notice and know where to turn in the driveway and so forth. So it would be, practically speaking, impossible to operate the retail portion of the mixed use that you've approved without some kind of appropriate signage.
You're asking for a sign both on the building and freestanding?
I'm asking for both.
Okay, so that's, just so you know, that's another another aspect of variance, because in residential, you're only allowed one sign.
One sign, yes. And if I can explain, I understand that two signs is certainly, not as of right in a residential zone at all. But particularly the sign on the building itself, its main function is to, because it's a mixed use, its main function is to indicate which door of the building one should go in if one wants to transact business, as opposed to knock on the door of a resident. And so that sign, as you'll see in the, I think it's the next picture there, Shelley, that sign is actually in a recessed alcove. That's about a 3-foot recessed alcove, so that it really is only visible if you're directly in front of that portion of the building. It's not visible from the other side.
Now, is that the one that's...
No, that is a mock-up. That's a...
I know the mock-up, but that's the size of the sign.
That would be the size, yes. The sizes are more explicitly described in your written handouts. The one on the building would be about 15 square feet of sign area, 6'8" wide, 2 foot and a couple inches tall. The street sign would be 23 square feet, just over 8 feet wide, and 2 foot 10 inches tall, the sign panel. Also in your written information there, I've taken a survey of all the other signs in that neighborhood, because I know part of the deliberation is whether I'm making a negative impact on the neighborhood in general. And so you see the list there. There are quite a number of them. 2 of them are in a business zone. That's the mobile station car wash at the traffic light there, and the veterinary clinic are in a business zone. The mobile station car wash thing, I think even for a business in that area, they have far more signs than would be available by right. I was looking at all of them. But the other ones, Indian Hill Music Center, the Littleton High School, St. Anne's Church, and the Pond Side, the Pond View, I think it's called, isn't it? A condo development are all in residential districts, and they're all as large or larger than the street sign that I'm requesting. We've also, as we designed the sign, we've also tried to take into account the preferences of the bylaw in terms of the sign background color being the same as the color of the primary color of the building, things like that.
How are they lit?
The street sign would be lit from below, similarly to the way the Indian Hill sign is lit. We're planning on, LED lights closely focused, so minimizing light spill. The sign on the front of the building is simply lit by the lights that are there anyhow in that enlarged soffit on that recessed portion of the building. So there are recessed lights just for entry purposes under that large soffit of the building, and they indirectly light the sign.
What did the Webbers have?
The Webbers have had a series of signs. In this photo, if you look, the part of the building that juts forward towards the street, there's a triangle up there above that little porch roof. You can just see about half of it in the right-hand part of that photo. They had one large triangular sign that said flowers that occupied that entire triangle. I haven't measured how many square feet that would have been, but it's fairly sizable. And then for a while they had the sign that was projecting out from the peak of that roof. It was a diamond shape, roughly 4 feet by 4 feet, maybe a little bit bigger than that. I still have both of those signs. They left them behind. And they also show up in some of the historical photos that I think I presented the last time I was before you.
Will the lighting on the signs be 24 hours, or is there a
No.
timer?
The lighting would be while we were open, which means weekdays and Saturdays until 9 PM. I mean, sorry, Saturdays till 5 or 6, depending on the season. Weekdays mostly until 9 PM.
Again, this is kind of a continuation of signage that's been there for a while, just a different design.
If the board's done with questions, I think we have a butters on this one.
I have a question. No, I have
Go ahead.
one, I just have one more question.
Yep.
The street sign, and I think it's tasteful, will draw people off the street. Then the sign by the door is gonna draw people to the door.
To the proper door in
Can't
the building.
that sign, I think, could probably be quite a bit smaller
Could be,
and still serve its purpose.
could be.
That's exactly what my question was gonna be. I think, I just think that, I think your street
Could be.
sign mock-up, I think it looks great. I think it's
I mean,
terrific.
one of the building could be half the area.
Yeah, I mean, I think you could do something really nice and elegant and small and tasteful right by that door. That would actually look a lot better than what you have there. That's a sign that looks like if you're across the street, you need to see it to see
Right.
where you're going.
Yeah.
But since you're already there, I think you could do a lot better than
Yeah.
just.
But that's
It's
a
a design
point.
issue. It's a design
No,
issue.
it's more than that. It's a point I wanted to make. I went by the facility on the way here. Beautiful, by the way. Beautiful renovation that you're doing, and it's so tasteful. I was thinking about why he needs the signage and what the signage does for this business. First of all, an arts business, to me, is very different from, a manufacturing business. But I think that it's effective to have people who are congregating at the church for all sorts of activities to see what is across the street and what a nice community addition this is. And if the abutters don't have a problem with it, I've got no problem with the size of that sign because it's some sort of advertising to the parking lot at St. Anne's. It directly hits the parking lot at St. Anne's.
Wouldn't they see the street sign as well?
If they go in and out at St. Anne's, they're gonna see the street signs
Well,
too.
there's
Looking at the
that.
street sign edgewise,
Yeah, but they'll be driving.
but they would be driving.
Coming in and around.
It's a very massive building and it's a very small single entry, so I didn't have a problem with that. Was the mock-up there? What's the size? Was there a size?
Excuse me?
Was there a mock-up on the wall tonight? I didn't.
No,
notice.
there was no sign on the wall. The wall is painted yellow now.
Yeah, very good looking.
But didn't,
The cloud
I saw, when I went by, there was a banner or something that
On the
was.
street.
We have, again, pursuant to the bylaws, we have a temporary banner
Okay.
out
I
in
guess I
roughly,
saw it on the wall at one point.
it was in front of that porch area, the triangular area you see at the right. It was in front of that for a few days. And then pursuant to the bylaw that allows us to have a temporary sign for situations like this for 30 days, it was there for a few days, and now it's been out front up until we get a permanent sign. But the design of the sign would be very similar. It's simply the store logo.
And
Abutters.
abutters.
Diane Curry, 74 King Street, direct abutter, and they've been wonderful neighbors so far. We think that the signs are great. They actually invited us to come over and take a look inside, and we have no problem with either sign. I think that they're very tastefully done, and they actually spoke to us beforehand to let us know where they were actually going to place the signs, so that when we were coming out of our driveway, we wouldn't have be impeded, which I thought was wonderful, because a lot of people wouldn't take the neighbors into consideration.
Very true.
We were very grateful for
Well,
that. So.
we want to be good neighbors.
Any other comments? Any abutters, board?
Yeah, just another, I agree a little bit with Alan. The sign on the building is a bit on the large side. The rationale that, it's advertising, that makes us business partners, not a regulatory board. Much like yourself, you start allowing this, other people, the board has set precedents. They come in and, you let this company do it, this
Well,
company.
in fact, I'm pointing to the Indian Hill Music Center sign, for example.
So, I wouldn't insist upon it, but, I'd feel better if it was a little bit smaller. To be honest, I think it's really big for, if the main purpose of the sign is to direct people to that entrance, it's much larger than it needs to be. So from that rationale, which is the rationale.
No, those are
you gave,
interesting comments, and
Yeah,
and I take them.
I would say it should be smaller then.
As a-
That it provides advertising, well, that's,
But purely as a design architectural thing, I take your comments that perhaps it's a bit larger than it should be.
It actually kind of looks a little out of scale.
Yeah.
Yeah, actually, yeah. You get nice cedar shakes here. So that's the only comment I had. Other than that, yeah, you've been doing a great job fixing that building up, and I think it's a fine addition to the town and the area.
And like I said before, you have the best presentations that we've seen.
Yeah, really, I have to come.
It's a way to get to a decision quickly.
Yeah.
To explain the situation, so.
I need to clarify the height of the sign, please, from the
Yes.
ground. This is the freestanding, please.
It's 4 feet from ground to bottom of the sign,
Okay.
so.
So, polling the board, is everyone generally in agreement that the freestanding sign is no issue?
Correct.
You're okay with the colors?
Yes. Colors are great. It's
Yeah.
a nice looking sign.
Okay, and let's talk about the building sign. Do you want to propose a size?
No, I mean, my feeling is that I would vote for both. But I would just say that I think you could do a lot better, and it could look a whole lot nicer if you had a nice, smaller, elegant treatment by the door. But I'm not gonna vote against it.
Jeff?
Well, I don't mind the size of the sign. It's funny, because I am an architect, and I don't mind the scale of the sign by the door. But it could be smaller, sure. And I'm just wondering is, when we do our decision, we have to give a variance for 2 signs. And we could give the decision in such a way that it gives the size of the second sign on the building of the size he's shown, and then it would be up to you whether you want to do it smaller or not.
Right, and as a design matter, I will certainly think about, maybe smaller is actually better in this case.
Do that?
I think I echo what Alan said. I'd prefer it smaller.
Echo what
but I
Alan.
wouldn't fight against it.
And Mark?
I agree with Alan. I think a smaller sign, again, just from we're sort of, not the right word, but we're intensifying the variance by saying, okay, not only can you have one sign, you can have 2 signs, and no, not only can you have 2 signs, but one of them's got to be bigger than you really need. So, and again, someone else is going to bring it in. Well, minor chord did it. Can I do it? So I think a smaller sign. I'm not going to propose a size. What's the proposed one?
The one of the building is around 15 square feet, I believe.
Like
Yeah.
3 by 5.
Right.
Yeah. Should you be willing to propose a smaller size?
How about 10 square feet? Give me some room to
Yeah,
work.
2 by 4, 2 by 5.
Yeah, 10 square feet would be 2 by 5, which, and
Even that would,
maybe
a
maybe I don't
static
even
would
need it
be-
that big.
2 by 4 would be a better proportion, but, well, let's see, what is it, 3 by 5, so,
You're no greater than 10 square feet.
yeah, okay.
What's he at now, 3 by 5?
15.
Well, the one on the front he says is 23 square feet.
On the face of the building?
Face of the building, it says 15 square feet.
Why don't you go to 12, just because 2 by 4 is long and narrow, and maybe a sign guy will
Well, I
think 3
said,
by
we
4.
were thinking just 10 square feet, you can pick whatever.
No, I'm saying 12 square
No.
feet, so you can go 3 by 4 and have it more.
Okay, yeah.
Well, we can always go 2.5, but, 3.5.
We're not designing the sign.
Yeah.
We're not designing
No,
the
he
sign.
said 10 feet, square feet, I like that.
I think
I
10
would
square
accept
would be enough.
So we're putting it not to exceed, but he can decide to make it smaller if he wishes.
Whatever proportions.
Without
Save you a little
casting
money.
any aspersions at all on you, I've had so many people say, we're so happy Rosanna's in town, but you can barely read her sign and her phone number's not on it. And we're not in a residential zone, but I really do believe, and we've had this discussion before, I don't agree with you that there's precedent being set because this is a unique property and that's the whole reason you have a variance. Everything about it is unique. Second of all, every single decision we've made on sign variances along Route 2A has handled and dealt with the speed of traffic, the speed at which they're flying by. Now, the sign on the building isn't that, I understand that. But for us to sit here and nickel dime a couple of square feet on a sign, I would rather have him on site decide it's either aesthetically pleasing or not, but to let him have signage that's meaningful so that somebody isn't, turning to look at, oh, what's that? And they can read it and they're not saying, what is it, while they're driving at high speeds down Route 2. That's my feeling.
I tend
But with
to agree with you in terms of maximum size.
Well,
what
I
it
guess
is
I want to
right
remind
now.
us about the FIBA sign that we approved, which really sets the precedent for a gigantic youth sign.
Because it sits back from the
It
road.
was, and that's one I thought was too big, and
Yeah.
it turned out to be too big, yeah.
Yeah, well.
It'd be nicer to be.
Okay, so it's,
But on the other end of the spectrum, every time I drive by the Toyota dealership, that sign is too small.
really?
The one out by it is
I don't.
a larger building, you look at all the other, I just,
It's hard not to know what these
I don't think I was a voting member of that, but that bothers me whenever I see it, that we forced them to make a smaller sign in that particular case. It is out of scale with the business, but anyway, that's.
So we've
I think it's
all, we've
fine.
all said we've pulled. I'm going to ask to close the hearing. For a
So
motion to
moved.
close. And second?
Second.
And then I think in fairness to the applicant that's been sitting all night, we really should go back and deliberate and decide the first hearing and then come back to Carl's. What I will say is this, if nobody minds, and I don't know, do we still have a butters on the first hearing?
Yes.
I have to recuse because I have financial interest, but I'm usually the decision writer. So if nobody objects, could I sit in the back quietly and take the notes on the deliberation so I can write the decision? Anybody have a problem with that? Thank you. You?
Thank you.
So we're going to go back to the matter of 39, case 865A, 39 Washington Drive. We've closed the hearing. We're going to have our discussion. I'll start with Roseanne. We'll just go around the table and let me remind everyone that in this matter, we are voting to either uphold or override the decision of the building inspector to deny a building permit for the lot at 39 Washington Drive.
So legal control, I just don't see it. And especially given that a building permit was issued for the first house, which seemed to imply a decision that these were two separate grandfathered lots. And I don't read this as fitting into any of the case law cited to demonstrate any kind of legal control. Yes, they were business partners, but I don't see the legal control on either side for either of the other pieces of property.
Mark?
I think the original intent of the law, and perhaps people more familiar with it can correct me, but it was to prevent somebody from taking a big lot and making it into two smaller lots. I don't think there's any argument that these were two separate lots for decades, if not since it was first laid out, and that for a brief period of time, there may have been the perception that they were merged because of the names on the deed and whatnot. But we'd need to deal on the facts, and we have two separate deeds with two separate names on it, and the people know each other and do business dealings, but they don't have legal control over each other's actions. So I tend to feel that no, there was not common ownership, and the lots were not merged for those reasons.
Yeah, I think the applicant made an adequate case for the fact that they're not under common control or legal control. And besides that, they were individual lots, and I have a problem with any law that takes the rights away just by saying they're merged or something like that anyway. So I think they should retain the right to deal with them as separate lots.
Yeah, I think I'm uncomfortable with how the whole thing went down, frankly. And it's a very tiny, if you put the two of them together, from what I read, it looks like even the two of them together is really not very much for one house. So we're really squeezing two houses in here. I think the fact that both of the sales happened at the same time, that one was for $90,000 and one was sort of a tack on for $195, that doesn't look right, doesn't feel right to me. I think the fact that we had originally some, assumption by the sellers that it was going to this GS Holdings, and just sort of a mistake that came up. I can't, that seems really odd to me. But I think in deference to the law that I see, I don't think there's any way to really stop it, but it just doesn't seem right to me. But it seems legally like we don't have a way to really stop it.
Okay. I think everyone's brought up point. I think the facts of, I sort of agree with you. I think this was careless or whatever, but the facts of the case are that I believe they were never merged. And the fact that the town issued a building permit for 30 or 43 or whatever, and the planning board issued decisions assuming there were 2 lots there, that is a further matter that I think we can't ignore. Anyway, do I have a motion? The motion would be to override the building inspector's decision to deny a permit for 39 Washington
There
Drive.
was no denial of the permit. It was, there was no permit application.
Okay.
So it would be
But it was
his
a-
determination.
His determination, to override the building inspector's determination that this 39 Washington Drive was not a buildable lot.
So moved.
Can I have Alan second? Rod and Alan, you're a team today. May I
As
have
long
a
as you
vote?
make the motion, I just have to say so.
Can I have a vote? Who's in favor of the motion?
Aye.
Any opposed? The motion carries. Now, you can check to see if there's any appeal. You have the right of appeal, and I don't know the ins and outs of it, but you can check that.
Can I ask who made the motion, please?
Rod made the motion?
Thank you.
Rod, yeah.
I so moved what,
Okay, thank you.
what he said.
And Alan seconded?
If you're missing any notes, I may have some.
Thank you. Okay, now we can move to deliberate on the Strathmore application, so let's do it easy. I'll take a motion on the conversion to the two-family into 17368.
Rod has to so move, and you have to second.
So moved and
I'll
seconded.
second, okay.
Okay, that's on that one.
This is for the special permit?
Yeah, okay, let's go to the hard one, and that's the signs, and I'll shut up now. So, you want to make a motion? Anybody want to make a motion?
I move that we grant a variance for signage in a residential district at whatever this address is, 80 King Street, which would consist of a freestanding sign shown in the submittal and a sign mounted on the building of a size, did we say 10 square feet? Or not to exceed 10 square feet?
Yeah.
Would everyone support that?
Yeah.
Okay. Not to exceed 10 square feet. Both signs to appear substantially as presented in the submittal
Right, and the street sign to be illuminated during business hours.
only.
So
I think we should state the hours. Are there illumination hours in the residential sign?
I think the hours are 9 or 10.
We'll have to look for a minute, just a minute.
But since this is a business use and they're not gonna be open all night, I think.
they're open late, though.
Well, you said 9 o'clock.
Well, you'll have later nights when they have their, when you have the
Lessons and performances.
recitals. Thank
Yeah,
you,
but for
performance
safety
recitals.
purposes, people trying to find it and so on, I think it should stay illuminated while there's people in the premises.
It says, our illumination bylaw says,
No sign should be illuminated between the hours 11 PM and 7 AM.
Okay.
I think that's what we should leave
Indicating
it.
time, temperature, or establishment open to the public during those hours.
So I think that's the way we should just.
So if we
word
say,
it.
In accordance with.
In accordance
No,
with
okay.
the signage regulations.
Illumination hours in accordance with the bylaw. Is your sign, is that Just tell me where that was, please.
173-34.
At the beginning of the
paragraph
signage
E,
section,
with the
page.
dog.
So it's overall for
20.
all signs, it's not just,
Yeah,
Right,
it's the general regulations.
Upper left-hand,
Yeah, got it,
page
thank you.
20.
Yeah, that's probably
that's fine,
sufficient.
okay.
Don't have to say
Okay.
during business
Yeah.
hours, just.
so who
say-
wants to second that? Who wants that motion?
Well, you have to second it.
Second.
Who made it?
Who made the motion?
No, this is Alan's.
made
I
it,
was
right?
making the
Yeah.
other
Yeah.
ones.
Yeah, Jeff
Oh, you
just
made
made
it.
it. Jake, come on, own up.
I'll second
Jeff
it.
made it, and who's seconding?
I'll second it. Unless
It's a
Jeff
tie.
wants to second.
Cut your word.
Rod wants it, he can have it.
I don't care.
Okay,
Do we have to vote?
yes, all those in favor signify by saying aye.
Aye.
Opposed? None.
I think my role here is to remind Jeff to call for a vote and remind
know.
you to appoint an alternate.
I just want to.
It's a good roll.
Thank you, everyone.
Thank you.
Good luck. When do you open?
Yeah,
Go.
we're opening this coming week, so.
So are you moving out of your other store?
Yes, yes.
Oh, good luck with your opening.
Yeah. They have a tenant in line for your old place?
We have, the apartments, we are kind of sprucing them up a bit, and that work has taken second place to getting the store in shape so we can move our operation over there. Commercial rent, as you might imagine, in that strip mall is crazy expensive, so we wanted to get our business, the store over there, probably another month, 6 weeks, something like that, until we get the apartments done. But we already have, just from our customers, friends of our staff and so forth, we have, 1 and 2 deep waiting lists for both apartments, so.
Oh. No, I meant in terms of the space you're presently occupying. Do they have a potential tenant for that?
I doubt it.
Yeah.
There's been, they brought one supposedly prospective tenant in right away after we gave notice. I think that was more to impress upon us that we really had to be out there.
Yeah.
There's been no one since, and the Verizon office next door has
It's
been
empty.
vacant for close to a year now.
Yeah.
The karate studio on the other side of us was vacant for over a year before Abishan agreed to move in there. So, no, I don't see any immediate tenants in the pipeline.
Yeah, I hate to see them sit empty.
Okay, no.
Move
No.
to adjourn?
No,
Yes.
before we
We have some more
adjourn,
stuff? Yeah.
let's talk about decisions. What do we have? We have to write it, 39, okay, you want to do 39 Washington?
I'll write the decision.
Okay.
I'll write the decision on 39 Washington, and if you want,
And we've continued Oak Road.
Yeah.
I'll write
this,
Evergreen Road, that's easy, yeah. Yeah, that's, and.
this one will be easy, I'll write this one.
Okay, so clerk, you have to bug me and Sherry. Okay. Okay.
It's easy enough. I know where you get coffee. It's easy enough. I know where you.
Oh, are we done?
Wait, we have to move to adjourn.
Yeah, I just did.
Moved.
Rod moves to adjourn,
Exact
second.
picture of what?
All those in favor?